This video examines the Supreme Court case of the Salvation Army versus the Social Security system. We will cover mandatory Social Security coverage, the fourfold employment test, and constitutional considerations regarding religious freedom. In Part 1, we explore the background and facts of this dispute, focusing on the 1962 voluntary registration and the 2005 petition regarding the status of religious ministers. The Salvation Army initially registered with the SSS in 1962, classifying officers as employees. In 2005, they petitioned to convert this status, citing their ecclesiastical nature. The SSS denied this request, citing a lack of legal basis. The procedural history includes a 2006 SSS rejection, a 2013 Social Security Commission resolution confirming employment status, a 2016 Court of Appeals dismissal, and finally, a 2021 Supreme Court judgment. Key contentions involve the petitioner's argument that their relationship is strictly ecclesiastical, versus the court's ruling that statutory employment duties apply to all entities regardless of religious status. Part 2 examines the ecclesiastical doctrines, specifically the analytical framework the Supreme Court used to distinguish between secular employment and church affairs. The court established that while ecclesiastical affairs concerning faith and worship are beyond state interference, determining employer-employee status for social welfare is a secular matter subject to judicial review. The court applied the fourfold test, which looks at the selection and engagement of the employees, the payment of stipends, and the organization's power of control over work. Statutory coverage is broad. Under Republic Act 1161, religious and nonprofit institutions are not exempt from compulsory SSS coverage, as ministers are not listed as statutory exceptions. Part 3 covers constitutional doctrines, evaluating religious freedom, non-establishment, and the legal invalidity of waiving statutory rights. The court found no infringement of religious freedom, noting that SSS laws are neutral and serve the public welfare. Furthermore, individual waivers of Social Security coverage are considered void, as they contradict public policy. In summary, religious organizations act as statutory employers for Social Security purposes. Religious vows do not grant exemptions from these mandatory secular obligations. This video utilizes images sourced from pngtree.com and unsplash.com.